We wait for complete reports. That is my office's policy.
You can't prove and charge any of these, so you don't want to file anything?
I don't charge based on probable cause. I charge based upon beyond a reasonable doubt.
Then we cannot have bail. So you are discharged from all bail forthwith. Now, cash will be returned to you, bond.
DA Kevin Schmidt held a man on $1,000 cash bail for 33 days without filing a single criminal charge. And when a judge finally demanded answers, Schmidt's defense was that his office doesn't charge people until they can prove guilt beyond a reasonable doubt at trial. Let that land for a second. The legal standard required to arrest someone and hold them.
Mr. Campo, this is a 1 o'clock, but it is a GF. And this man and his wife just walked 2 hours to be here this morning. And I don't believe that we have anything filed, do we?
No.
You can have a seat, sir.
On foot because they have no car. Because the court date was set at 1 o'clock and Brandon Campo, a man who had never been formally charged with anything, was trying to get the date changed because he couldn't afford a lawyer and didn't know what he was even supposed to be preparing for.
And so he's here, was scheduled at 1 o'clock, but the man and his wife have walked 2 hours to get here. Correct, Mr. Campo?
That's correct.
You don't have a means of transportation?
No.
And so why are you here at 1 o'clock? Or why are you here now instead of 1 o'clock?
I was trying to get the court date changed because I don't have an attorney.
Because you don't have an attorney.
He showed up in a shirt and a tie. He showed up respectful. He showed up the way people show up when they still believe the system might treat them fairly if they just do everything right. The judge noticed the tie, complimented him on it.
I would say probably no, because there's nothing filed. But you do have cash, $1,000 cash that was posted based upon a very lengthy probable cause statement with facts enough that you could have been charged or probably should have been charged by now, since it is June 24th. Almost a month past the date. You are dressed very nice for court. Thank you for wearing a shirt and a tie. You look fantastic.
And then turned to DA Kevin Schmidt and asked the question that should have been asked 33 days earlier. Why has nothing been charged?
Why don't we have anything charged? Almost 1 month. Almost 1 month to the day or two later.
Because one of the charges lacks probable cause in the police reports.
Then don't charge that charge, but he should be charged by now.
No, because I've asked for police follow-up to find the probable cause for that count.
I thought you started something in Polk County where the day that they're arrested, they get probable cause.
Schmidt's answer was simple. His office has a policy. They wait for complete reports before filing complaints. They need everything, every document, every follow-up, every clarified detail before they will put a single charge on paper, because in Kevin Schmidt's office, you don't file until you can prove it at trial. Not at probable cause, not at initial appearance, at trial. Day 1 of trial, Kevin Schmidt wants to already know he's going to win. The judge's response was equally simple. Then we cannot have bail, because here is the legal reality that DA Kevin Schmidt's policy had quietly shredded. When a person is arrested without a warrant and brought before a court, a criminal complaint shall be filed forthwith. That is not a suggestion. That is not a best practice. That is the statute. Forthwith, the state must file a complaint without unnecessary delay following arrest, which the court interpreted as 48 hours.
The state must file a complaint without unnecessary delay following arrest, which generally can be interpreted as 48 hours. 48 hours. And that's not just for the court to determine bail, but it should be filed. It should be filed with unnecessary delay.
Not 33 days, not whenever the DA's office feels confident. 48 hours. And Burnett County had not been doing that. Not even close. But the judge pointed out that when Schmidt previously worked in Polk County, complaints were filed the day of arrest. Amendments were made later if needed. Charges were filed, defendants had rights, victims had timelines, and the system moved. Here in Burnett County, the system had apparently decided that waiting indefinitely, silently, without notification to the defendant or the court, was just how things worked. One of the little counties, the judge said. One of the little counties that apparently doesn't want to do that. Brandon Campo never appeared before a judge for a bond
But
hearing.
it should be filed. It should be filed with unnecessary delay. And to this court, this has been beyond an unnecessary delay. When a person is arrested without a warrant and brought before a court, before a judge, a complaint shall be filed forthwith. Forthwith.
This person was never brought before a judge. Bond was set in his absence.
Well, his bail was set in his absence. A probable cause statement was submitted to the court. The court made a finding. $1,000 in cash was required. And Brandon Campo's freedom of movement was immediately restricted, all without him ever standing in a courtroom, all without a single charge formally filed against him, all without any of the constitutional machinery that is supposed to exist between a citizen and the government's power to restrain them. He didn't even know if he was going to be charged. That is what Kevin Schmidt's policy had produced. A man living under bail conditions, risking a bail bond violation every day, comfortable for an allegation that had never been formally made. Miss Bauer, the victim, was sitting in the back of that courtroom.
But it is a GF, and this man and his wife just walked 2 hours to be here this morning. And I don't believe that we have anything filed, do we?
No.
You can have a seat, sir. We will go on the record in the matter 26 GF 133, group file of Brandon Campo. Appearances are we do have appearing in person the district attorney, Kevin Schmidt. Mr. Campo appears in person without counsel. We are in victims' rights compliance because the victim.
The judge pointed directly to her, said, "Look at her face," said, "That is who she is." Comfortable. A real person whose case had been handed to a DA's office that was so committed to only charging cases it was certain it could win that it had left both the defendant and the victim suspended in procedural limbo for over a month. When the judge pushed back on Schmidt's rationale, Schmidt held firm. He said the probable cause statement from the Siren Police Department was incomplete.
And all you do is cut and paste and put their complaint into the complaint or their police reports into the complaint anyway.
Judge, the probable cause statement, you may have noticed, does not state when the drinking occurred in regards to when the crash happened, does not state when the moment of driving was. It does not state whether an officer was actually spat on or not. And it does not say whether anyone was injured in the crash.
Well, then.
It didn't specify when the drinking occurred relative to the crash. It didn't confirm the exact moment of driving. It didn't clearly establish whether an officer was actually spat on. It didn't state whether anyone was injured. These were the gaps that, in Kevin Schmidt's judgment, made the case unready to charge. The judge's answer to that was sharp and it was fast. That is a Siren Police Department training issue. Talk to Siren. But the county officers and deputies, the judge made clear, put serious work into their probable cause statements. Serious, detailed, thorough work, enough to file a complaint. Comfortable. Enough to cut and paste from a police report into a criminal complaint and get the thing on the record while the follow-up details get sorted through the normal process of amendments and preliminary hearings, which exist for exactly that reason. That is what the rest of the state does. That is what the statute contemplates. You file, you amend, you proceed. Kevin Schmidt said his office would not do that.
Don't charge based on probable cause. I charge based upon beyond a reasonable doubt.
Then we cannot have bail. Then we cannot have bail or bond conditions. So people need to be let out immediately, forthwith.
So the judge drew a new line in the courtroom in real time on the record. 0 bail, 0 bond for any arrest in Burnett County going forward. If a criminal complaint is not filed forthwith, within 48 hours, no bail will be issued. None.
Right. Forthwith, within 48 hours, I will do bail. Within 48 hours, we will have the initial appearances in every single arrest, every single that comes in front of this court for bail and bond.
Okay. I will speak with law enforcement of what the court's command is. I am going to be gone for the next 2 weeks, so there will be that problem.
Because to me, forthwith does not mean 1 month and 2 days after an arrest.
The court will not place cash bond conditions on a human being if the DA's office is not willing to formally allege what that human being is accused of doing. If the DA's office cannot commit to filing a complaint at the bond hearing, then there will be no bond hearing. People will walk out the door. Not because they are innocent, well, not because the evidence doesn't exist, but because the Constitution requires that when you hold someone, you tell them why in writing, officially before a judge, and you do it fast. Schmidt said he would need to confer with law enforcement, said they hadn't been consulted, said they hadn't been given an opportunity to prepare. The judge pointed out that law enforcement had been preparing every single time they wrote a probable cause statement, and those statements were already packed with the information needed to file. The preparation, the judge said, was already done. All that was missing was Schmidt's willingness to file.
Due process rights taken away because we can't get a criminal complaint filed forthwith.
I agree. It is unreasonable for people to be on a cash bond without seeing a court and no.
Any bail bond conditions, because right now, this individual, if I have him on bail bond conditions, this individual, and he's not getting a complaint filed a month and 2 days after, why should he risk to have bail bond jump violations when he hasn't even been charged? He doesn't even know if he is going to be charged.
I agree.
For Brandon Campos specifically, the ruling was immediate. No complaint had been filed that day. No complaint was coming. And so the bail bond conditions placed on him on May 26, 2026 were dissolved on the spot, forthwith, immediately. The $1,000 in cash seized from him would be returned.
So zero bail, zero bond, unless we have a criminal complaint filed forthwith within 48 hours.
I agree.
Done. Then that's what we're going to do. So, Mr. Campo, I'm not sure if you are supposed to have a complaint filed today. I'm hearing no.
Okay.
So you are forthwith discharged from all bail bond conditions. Forthwith. Now.
Really?
Immediately. Cash will be returned to you. And bond, gonzo.
Amazing.